So I deal with people who are going through a lot and they're stressed out, they're overwhelmed, they've got a lot going on in their lives and they really need support, assistance and help. And when you deal with these people, I kind of try my best, and it's not always easy to do, but to really empathize with them and see the world through their lens. Today, we're going to talk about a topic that lawyers are very familiar with, and that topic is dealing with difficult people. In the business of law, you are going to meet people from all walks of life. Some you're going to like, some you're going to hate, but all of them are coming to you because you've got a fundamentally complicated problem that they cannot solve. And they've decided to engage with a lawyer to assist them through that process. So I think the first lesson that young people in the law need to understand, and even older practitioners, is you're dealing with people's lives, and people's lives are complicated. So even a commercial dispute where you've got a CEO arguing over a sum of money, while there may be less emotion to it, it's still sufficiently complex that they have needed to engage your services. And this is something I've really struggled with as a lawyer, because sometimes you deal with jerks who are just awful and nasty and mean, and sometimes you're dealing with people who are in pain, who are stressed, who are overwhelmed. And obviously the approach that you need to take is quite different between the two different classes of individual. So for a moment, let's ignore the jerks, and I'll speak to that, I guess, a little bit later, but let's speak to people who are in pain. I do family law, I do criminal law, I do human rights and refugee law. So I deal with people who are going through a lot and they're stressed out, they're overwhelmed, they've got a lot going on in their lives and they really need support, assistance and help. And when you deal with these people, I kind of try my best, and it's not always easy to do, but to really empathize with them and see the world through their lens. So often my clients, particularly clients from non-English speaking backgrounds, from low socioeconomic backgrounds, they just don't understand the system. They've never been educated in it. They may not have substantial understanding of the language. They certainly don't understand the practices and procedures. And often they can't even articulate what the case is about. So, if you've got a refugee case and a person's fled persecution, it's very clear to them that they want to stay in Australia. They understand that seeking judicial review of an administrative decision in order to obtain that outcome is just unfathomable to them. And so I always start with the end in mind, which is, what is the key pieces of information I need to convey to this individual to do my duty correctly? And two, what information do I need to receive from this individual in order to do my job correctly? So, for example, in a criminal matter, it might be, there's a real chance you're going to go to jail. We're going to do everything we can to avoid that. That might be what I need to convey. And I might need to say that in a variety of different ways, stemming from very, very directly to kind of dancing around it to almost explaining it in a patronizing way, because it just might not sink in. But you have a duty to explain to someone that, hey, you may go to jail, because if they do go to jail and you haven't explained it to them, they're going to be terrified. It's going to be stressful. It's going to be awful. And so I think it's more important to convey that information, even at the expense of your own having that hard conversation, than it is to avoid it. And secondly, it's the obtaining of instruction. So how can I get information from this person that will help me keep them out of jail? Like, what is their story? What is their defense strategy? What is the information that's going to help me understand the facts in the right light, understand the rationale in the correct light, and really enable me to take this case forward? So that's the way that I try to break it down into, what do I need to get and what do I need to give? And I have found that to be a pretty powerful way of structuring the conference. When you go into a conference like with an intention, here's the stuff that we must convey to them and here's the stuff I must get from them, it allows you to sort of prepare your mind for where the possible conversations can go, because you know that at the end of that conference you need to get these things and you need to have said these things. It really does remove a lot of the detritus and confusion, because if you don't control a conference well, it can go for hours. It can go for hours and not achieve anything. So it's really important to be super succinct to the extent necessary so that you get the information to them in a format they understand. So that's when you're dealing with people who, maybe a little overwhelmed, maybe you've got a lot going on, but really are still, doing the right thing. Let's jump ahead to jerks. Let's jump ahead to people who suck. People who are just in pain and they want to inflict pain on others. Now, early on in your career, unfortunately, you will have to deal with these people. It is a sad fact of reality that younger practitioners you won't know how to set limits effectively. You won't know whether someone's pushing unreasonably or not reasonably. And the only way to kind of get a feel for that is time. Once you reach a more senior level, you can push back on clients being like, you don't speak to me that way. If you speak to me that way, go somewhere else, or I'm not going to deal with you. And sometimes you even have to do that to other lawyers. Like, you will have to have a chat with opposing counsel where you tell them, hey, the way you speak to me is completely unacceptable. And if you don't fix your tone. We're going to have to take it in a different direction. And you do get better at that. I take a view that I'm going to operate in a no hostility environment, and you're allowed to advocate vigorously for your client, but you can't do it in a way that's offensive or inappropriate. And most jurisdictions have rules that allow this. Those rules are understandably open to interpretation, and some people take the interpretation that vigorous advocacy on behalf of your client entitles them to belittle, disrespect, be cruel, condescending. And obviously there's different elements and triggers and aspects to that. But from a holistic standpoint, people are going to try to take advantage of you, and you need to be able to stay firm. So when somebody's speaking to you in a manner that's not appropriate, I think it's very important to just say, hey, the way you're speaking to me is not appropriate, and we're going to need to revisit this because either one, alter the way you speak to me, or two, we're not going to do business. It's very hard to say. It's super easy for me hypothetically to make a video like this, but in my decade of practice, only in the last 2 to 3 years have I become comfortable with that. And the way I became comfortable with it is, I guess I psychologically intuited and understood this concept that conflict denied is conflict delayed. So I've in the past allowed clients to speak to me disrespectfully, to take advantage of my good nature, and just to ride me in an inappropriate way. And it's really hurt me mentally. It's been really difficult for me personally. And I realize now that I never should have allowed it to get to the stage it got, because when we finally did have the conflict, it was bad. And it was really bad, because had I stepped up earlier and said, you don't speak to me this way, go away, it never would have gotten that bad. So it's very important to understand that the conflict won't just vanish one day, that you need to be firm, stand up and say what you need to say as soon as you need to say it, because that's your job. It's your job to be a fearless advocate. So hopefully that helps.